All right, good evening, everyone, and welcome to our monthly Fit Town Hall. I am Rachel Gustafson, your host for the evening, certified financial planner here at the Fit team. It is so good to see so many familiar names on the call tonight. For those of you who I haven't met, it's nice to meet you via Zoom. I am especially thrilled to introduce Emma Crispin. She is an estate planning attorney here in Portland. She's someone that I call periodically when I have questions around estate planning or if I'm working through a scenario with a client. And a few weeks ago, we were chatting about common questions that clients are asking around estate planning. And I thought, this is a great idea for a segment on our monthly town hall. So here we are. A little bit of housekeeping. Everyone is muted, videos are off, so we would appreciate it if you kept yourself muted while Emma and I are going through this little interview that we're going to do. I'm going to be asking her questions for about 20 to 30 minutes. At the end, we're going to open it up for Q&A so that you can ask any questions that you have. The one request I have is to not have the questions be too personal to your situation. Emma's going to share her contact info so that if you want to connect with her afterwards, she can answer any questions you have. But for today, we're going to focus on broad topic estate planning, answering those types of questions. Emma, do you want to take a minute to introduce yourself and who you are?
I would love to. Thanks, Rachel. So like Rachel said, my name is Emma Crispin, and I'm an attorney at Ney and Friedenberg. We do elder law, estate planning, and probate work. We're located in South Portland, down by the waterfront. I'm licensed in Oregon, and I've been practicing for about 3 years now. I'd say maybe half of my work is estate planning, and the other half has to do with probate and public benefits. So it's a pretty even mix, but I'm excited to be here and talk to all of you.
Yeah, and I know we've got some members that are from Washington and some other states. We're going to be talking a lot about Oregon and broad estate planning, which is applicable in all states. But I always say within your own state, you want to make sure you work with an estate planner that understands your state rules. But we are going to get into some broad information. Why don't we start with Emma? I get asked this all the time. What is the difference between a will and a trust? And do we need both?
Excellent question. I think that's where I start a lot of my conversations with clients anyway, just kind of a background about what the different options are, what's available to you, how to decide. So a will is a document that I suppose a will and a trust are both documents that tell people where you want your assets to go after you die. Um, they have differences beyond that, but at its core, that's kind of what people think of when they're thinking will versus trust. It's something to direct distribution of assets. So a will is a document that really only comes into being, like, is effective after you pass away. So you can make a will during your lifetime, of course, but it doesn't really do anything until you pass away. And once you pass away, then your will tells the court, tells your family where you want your assets to go, gives instructions for payment of taxes and all of that good stuff. And it tends to be a shorter document. Whereas a trust, and there are a ton of different types of trusts, but a trust in general is more of a living document. So those tend to be active during your lifetime and after death. So a trust is kind of a like ownership name for assets, and you fund the trust with your assets during your lifetime. And then when you pass away, the trust already has instructions for exactly how to handle distributing assets. So you don't have to go to the court and ask the court to tell people what to do. So let's use the word probate. Will requires probate. Even though you're saying what you want the things, where you want your things to go, you still have to go to the court and say, hey, this was the will. Is it okay if we distribute like this? Whereas a trust, because it has all of the instructions within the trust and is actually a separate ownership vehicle, the trust avoids probate if it's properly funded, because the trust owns the assets and the trust hasn't died. It's just the owner or the settler of the trust has passed away. So Probate is required when there are assets that are stuck and there's no way of transferring them to somebody else. And with a trust, they're not stuck. They can be transferred according to the instructions in the trust. So you do need both sometimes. We do what's called a pour over will. So if we ever do a trust for people, we create a pour over will, and that's a shortened version of a will that basically just says, hey, court, if I forgot to put something into my trust and I die owning that, put it into my trust. So it's a shortened probate process and you don't have to go through all the different steps. It just goes to the trust and then that's it. The court steps back and the trust controls that distribution. It's important to have that kind of pour over will because otherwise, if you have a trust but didn't fund it fully, then you're still going to be stuck with probate and that's not great.
Uh-huh. Yeah.
Yeah.
Or you forgot to update it. How often
Yeah.
do you say people should be updating their wills and trusts? I mean,
Yeah, I mean, you should, anytime there's some sort of life change. So if you have more kids, if you have a beneficiary who's passed away, if suddenly when you did your will, you owned a car, bank account, and a house, and now you own a lot more assets, you want to update as you're going. And if you have a trust, anytime you buy a new asset, you want to title it in the name of the trust. So that's the kind of frequent updating that you're going to have to do.
yep. And the one that a lot of people forget.
Oh yeah, it's super easy to accidentally leave a bank account out of the trust, and then that's
Right.
why we have the pour over will always there to catch the leftovers.
Oh yeah. I used to work at the bank in the trust department and we would have clients coming in adamant that things need to follow the trust, but the account was never put into the trust. And so
Hmm.
explaining your financial institution will not abide by your trust unless you have put the account into the trust name. So that's an important step. And one that I think attorneys are getting a lot better at explaining to their clients, where in the
Hmm.
past it wasn't as clear.
Yeah, my
So
firm, oh,
yeah, go ahead.
I was just going to say, my firm does a lot of, puts a lot of emphasis on that post like signing activities. So the funding of the
Mhm.
trust, and we will actually like write letters of instruction and tell the clients exactly what documents to take to the bank. We tell them to make an appointment with somebody who knows what's going on before
Yep.
they go. And we follow up. So that's something a
Yeah.
lot of other law firms don't do, but we will follow up like every few months until they get us the information that we need that shows they did put it in the trust.
Right, right.
So,
Quick little tidbit, you got to go to the bank and change your bank accounts. It's an annoying task, but if you don't do it, then those accounts end up going through probate,
mhm.
as I understand it. Okay, with the estate plan, so wills and trusts, we talked about the difference between the two. Often clients come back to me and they say that their attorney is recommending things like a power of attorney. Can you kind of explain what a power of attorney is and why that might be important?
Yeah. Um, a power of attorney is a document that names an agent who can act on your behalf um, for financial and legal matters. So you would name somebody that you trust and hope that they maintain good trust with you. Because once you sign that document, most of the time it is effective with the signature. So you are basically giving someone the authority to act in all the same ways that you can act. So if you sign it, giving it to your spouse, then your spouse can then go to the bank and deal with all of your individual assets as if they were you. Um, I think when you think of estate plans in general, the power of attorney is one of the most important documents. So we like to do a will and or trust, power of attorney, and then a third sort of healthcare document, healthcare directive. But the power of attorney is really, really helpful because you need it when you're alive but incapacitated. So if you want to avoid going through like a conservatorship or like a court supervision process, you want a power of attorney because your agent can then do all of your financial transactions. They can defend legal claims, all of that. And just kind of going back a second on the will versus trust. The trust is effective during your lifetime if you've set it up. And so that means that your trustee can then manage assets for you if you have a backup trustee. Um, so that can help with planning for incapacity later on. Whereas a will, like I said, is only effective after you pass away. And so that's why the power of attorney is super critical because what happens in that time between before you pass away, but when you can no longer manage your financial and legal affairs. You need somebody able to do that for you. And you probably want to name that person rather than having a court or somebody else name them for you.
Yeah, I would rather decide who's managing my money than the courts.
Exactly. Yeah.
So we talk a lot about this idea of avoiding probate. Can you shed some light on what is probate and maybe why we want to try and avoid it?
Definitely. So probate is the court supervised distribution of assets and settling of the estate, basically. When you die, if you own assets that have no other way of being transferred, so if you have a bank account that doesn't have any beneficiaries on it, if you individually own a house, you have to go through probate. And I like to kind of think of it as probate handles assets that are stuck. So you need to ask the court for permission and for instruction on how to move those assets around, how to distribute them. And probate can take a very long time and can be very expensive. Sometimes there's multiple attorneys involved. I think in Oregon, the average for probate is about a year and it can cost $10,000. So it's a little ridiculous. That's why we want to avoid it, because not only is it expensive and takes a long time, it's also a very public process. So if you have a will, that gets uploaded to the court website. Everyone can see it if they know how to access that. If you all the documents, unless they're filed under seal or confidentially, which is unlikely in a probate, anyone can see that who knows how to get onto the court website. So a lot of people don't necessarily want it to be public record, who they're giving their money to, how much money they own. For example, in a probate, you have to submit an inventory pleading, and that lists all of the different property that was in your possession when you died, and the amounts too. So lots of people who are more privacy minded kind of balk at that piece of it. So privacy, expensive, and takes a long time.
That's when you start to get the calls from the family saying, "Oh, I heard so and so died, and I think they owe me some money."
Exactly,
You
yes.
just need a little bit of that. You guys want to avoid probate, okay?
And I
Uh,
mean, if at the end of the day, probate's not always the devil. It's not always the worst thing in the world. Like
Depends on your family. No, just kidding.
that's true. So I've actually heard some stories like probate couldn't be really helpful in a situation where you have two kids who don't get along and you know they are going to fight over every little thing. You might want to do a will and consider a probate because that has the court supervision. It has the judge making this final decision saying, hey, you two, this is how you're splitting it. Don't fight. Here you go. Whereas if you're just doing a trust distribution, I mean, everyone can get their own attorneys involved. It can really drag on. Like there's no judge to make the final decision unless it gets to the litigation. And at that point, you're spending way more than you would have for probate. It's taking longer.
Oh,
So it's not
interesting.
always the worst.
Another way to think about it.
Yeah.
Yeah,
But most people want to avoid it.
right. So to clarify, do wills escape probate?
That is a common misconception. No. If you have a will, you are still going to have to go through probate. A trust is a way to avoid probate. If you think about probate as a way to transfer these stuck assets, and the stuck assets are things owned by the person who died individually when they died. Um, the trust, like I said, um, will allow you to manage, like you don't have to do probate because the trust owns it. But if you die, then the court will have to say, this is where things go. Got a little lost on that answer.
Yeah.
Sorry about
Well, it's
that.
complex, you know. You've kind of explained it, I think, already, but why should everyone have an estate plan?
Lots of different reasons. It
Hmm.
kind of depends on your tolerance for various things. So we talked about the privacy part. So you should have an estate plan, maybe a trust if you want to be more private and not have all of your information in the court system. Um, if you, let's see, why do you want an estate plan? If you don't have any sort of estate plan at all, no will, no trust, then things are just distributed according to intestacy laws. And that just is statutes written by each state that determine where property goes if you haven't said otherwise. So usually it would go to the spouse, then to children, then up to parents, depends on the family members. But if you have a estranged child that you don't want to give any money to, you probably need to do some sort of estate planning and specifically say the reason you're not giving them money because otherwise there's a good chance that they could inherit.
Yep.
Related to that, if you don't really have close relatives, you could end up passing your wealth to a second cousin if that's how your family tree is set up. And we call that a laughing heir. So they didn't do anything, didn't expect it, but they still get the inheritance. So the
Yeah,
problem
we've
of the
seen
laughing
that too.
heir.
Right. So it's telling the courts where you want your money to go and how it's going to be distributed.
Exactly.
Another common question that I get asked is, well, who should be the beneficiary of my IRA? Should it be my spouse and my children and whoever my beneficiaries are? Or if I have a trust, should it be the trust? Should it be the estate? Who should be the beneficiary of my IRA?
Mhm. Good question. Uh, we talk about assets and probate assets kind of, you can think about two buckets for assets. So things like a regular bank account, house, real property, that kind of thing. All of those I would consider to be probate assets because they're not necessarily beneficiary driven, but like an IRA or other type of accounts like that that do have these beneficiary designations, those don't necessarily have to go through probate. So if you leave it to your estate, that's going to trigger a probate. You don't want to do that. There are other reasons not to do it, but I think, in my opinion, leaving it to your estate to trigger a probate is just a bad idea. If you were to leave it to a trust, it depends on the type of trust, exactly how it works, but there's a very high tax rate for trusts, and it would be taxed at the trust rate, these distributions from the IRA. It's really easy to get to the highest maximum tax rate of 37%, I think it is on trusts, versus individuals are taxed at a much more of a stair step situation. So it's
Right.
harder to get to that maximum tax level. Um, Additionally, since the Secure Act, they've kind of changed the timeline for withdrawals. So depending on the type of trust, it could be reduced to 5 years to withdraw everything, or 10 years. And with that high tax rate, it just doesn't really make sense to leave it to your trust.
Right. I
Yeah.
usually tell clients to double check with whoever did their estate plan to make sure who the beneficiary should be. Usually, if it's a basic family tree, husband and wife and kids, it makes sense for the spouse to be the primary and the kids to be contingent. If you have a
Hmm.
more complex situation, which might be charities that you're leaving money to, or a child where there's a spendthrift trust, there's lots of different situations. But if you have an estate plan, which you should have, we are encouraging it. You want to talk to your estate planning attorney to find out, but usually speaking, you don't want to leave the trust as a
Hmm.
beneficiary to an IRA for tax considerations and
Yeah, that's
complexity. It
right.
makes things really complex.
It does, yeah. And um, if you are trying to like split up your money and like giving little tiny pieces to lots of different people, a alternative to that is kind of splitting it half and half and saying, okay, this is what's in my IRA. I wanted to give about this much to these people, and you can just make those your beneficiaries. You do not have to deal with it in your trust. So it simplifies, breaks things up. And that has actually been really helpful for some people that I've done estate plans for because they were getting really in their head about how exactly, because they don't
Right.
know how much money they're going to have after they pass away. They don't know like who's going to get what when. So being able to say, okay, we can set up your beneficiaries on your IRA, and that money will go there. And then for your other beneficiaries, they'll get the trust assets.
Mhm.
It can help organize things in their head.
Yeah. Good point. Good point. What about Taxes, tax considerations for your estate. We've got some people again from Oregon, Washington, kind of in different states, but can you talk a
Mhm.
little bit about estate tax planning
Yes.
generally?
Yes, I can. So like I said, I am licensed in Oregon. We have multiple attorneys at my firm who are also licensed in Washington. So I know a bit about Washington, but I'll focus more on Oregon. Um, the Oregon estate tax is super low. The estate tax exemption is super low. So it's only $1 million that you get to pass tax-free in Oregon. Um, After that, it's taxed, and the tax can be pretty high, and people can lose a lot of money on that sort of tax. Uh, there are some really good strategies for tax planning, and those can be put in both wills and trusts. I tend to want to do those in trust because it's just a little bit easier. Like it makes a will really, really long. So at that point, you kind of just want to do a trust, in my opinion, but other people have other opinions there. However, there are different tax planning things that you can do. So if you're a married couple and you are wanting to do some tax planning, there are ways that we can preserve both of the couple's exemptions. So if you don't have any sort of tax planning going on and you're a couple and husband dies, then all of the assets will go to the surviving spouse, but that 1 million exemption is lost. So doesn't, it passes and there's no tax with that first transfer, but then when the second spouse dies, that's all going to be taxed and there's only 1 million exemption there. We can do different sorts of tax planning to actually keep that first 1 million exempt. So we can do something like a credit shelter trust, or there's a couple different methods for doing this sort of tax planning there. But what happens is you set aside up to $1 million, depending on the financial situation, from that first spouse's death. And that is the exemption. So you then get to pass that $1 million to whoever. It can still exist for the support of the surviving spouse, but that $1 million then can pass and you keep that 1 million exemption. So you're
Mm.
saving a whole bunch of money, like tens of
I think in
thousands of
Oregon, when it
dollars.
starts at 10%, something like that,
Yeah.
where, right, when you get to $1 million and your assets are over $1 million, and for most people, you count your house and your investments and you're over $1 million for most people, or quickly
Hmm.
approaching. And so that trust planning is protecting $1 million and then giving the spouse another $1 million when they die. Is that right?
Exactly.
Yeah.
Yeah, yeah. So that is super, super valuable. And I mean, if you think about setting up a trust with that kind of tax planning, you save on the estate tax and you would also save on the probate costs. So even though it can be a little bit more expensive to set up a trust and it takes a little bit more work during your lifetime to get everything titled in the name of the trust, it's worth it if you kind of look at the overall lifetime of your assets and taxes. It's usually worth it to do a trust if you're at a certain financial point, you know?
Yeah, right. What about things like an advance directive? What does that do for an
Yeah.
estate plan? What is that exactly?
Uh, Advanced directives are a healthcare document. You might have heard them called like a living will or healthcare advance directive. They are documents that do two things. So the first thing it does is appoint a healthcare representative, and
Mhm.
that person is in charge of talking to doctors and advocating on your behalf when you can't advocate for yourself. The second part of the document is you telling your healthcare representatives on paper how you want your treatment to be when you are in various situations where you can't speak for yourself. I believe they break it into three different scenarios, and they are all kind of similar, but there's like um, progressive illness where you can no longer speak or swallow or like live on your own, permanently unconscious, and then there's a third one. But all of these scenarios are situations where you are unconscious or incapacitated, you can't speak for yourself, and you do not have a hope of getting better. The doctors have agreed there's not really a chance that you're going to return to your previous quality of life or much of any quality of life. So it gives different options under each of those scenarios. And it says either I want all the support available, including tube feeding and artificial breathing and hydration. I want everything. There's an option that says, I want you to try to save my life, but I don't want artificial feeding and hydration.
Mhm.
A lot of people might choose that because they have kind of seen how people can be kept alive for a really long time with this feeding and hydration, when like if they didn't have that, they would have passed a
Right.
lot sooner, just uncomfortable to like end your life like that. So
Mhm.
a lot of people choose not to have the feeding and hydration. Then there's the option, don't do anything, let me die naturally. And then finally, the last option that we recommend people don't choose is let my healthcare representative decide for me. The reason that we don't recommend that is because the point of the document is to kind of say what your desires are, your wishes for your
Mhm.
end of life care. And by putting it back onto your healthcare representative, that can be a really difficult decision and situation to put them in. Um,
Not
I
just for
like,
them, but for the family. I had a
yeah,
client
for
who this
everyone.
happened to, and she was a daughter, and she was the healthcare representative. She had to make the choice about what happened to her mom,
Hmm.
and her siblings did not, to this day, have not forgiven her for her choices. And so it can cause a lot of problems within the family that people don't realize, making that, giving one person that choice. And even though
Hmm.
they do what they think is best, it still can cause problems within the family. So I agree with you on that one. You know, make your choices known within the advance directive. It's a really fun date night with your spouse if you're married. My husband
Yeah.
was like, "Why are we doing this?" It's important, honey.
Yeah, and I like to think of these advanced directives kind of more as conversation tools than anything. Like, yeah,
Yep.
it's a legal document. If it needs to come down to that, it's a valid,
Mhm.
it's got signatures, all that. But a doctor isn't going to look up the advanced directive and call someone like in the moment. If there's a
Right.
question about it later on about the decision, that's when you get called. But it, if they're doing life-saving treatment on you, they're probably not going to go look for your advance directive.
Right.
Um, I tell people that it's a conversation topic because it forces you to talk to your healthcare representatives that you have named in the document and explain why you've decided things a certain way, why these are your wishes. Talk about the end of life situations because that's really scary for a lot of people. And
Um,
all of the estate planning documents have to do with end of life and death and what happens to your stuff and your body after you die. So, just being able to kind of initiate some of those conversations is really important. And that's one of the reasons I like the advanced directive to kind of
yeah.
softly enter into that combo.
Right. And I think most attorneys recommend it at this point when because I know when I send clients to estate planning attorneys like yourself and you, they come back and they're like, well, we had to do a power of attorney and an advance directive and all these other things you didn't tell us about. And I'm like, well, they're all very important. And if I had told you that up front, you wouldn't have gone.
Yeah. The
So
advanced
really
directives,
important.
yeah, they are very important, but the advanced directives actually, it's a statutory form. So if you want to, you can download one from I think, Oregon Secretary of State, maybe. Your doctor's office probably has advanced directives to
Hmm.
fill out. Uh, we at my firm, we've kind of revamped the advanced directive. So there's obviously some required pieces that you need to keep in it because it's written by statute. But we've added things as we've seen over the past, 4 decades that our firm's been here, different situations that have happened. So we have instructions about comfort care. One of my favorite pieces that we've added related to comfort care is talking about how I want morphine or I want pain management, even if there's a risk that I may become addicted. If it's at the end of my
Mm,
life, it's
interesting.
fine. Keep me comfortable.
Yeah, right.
Yeah,
Well, if you're at the end of days, you probably want to be comfortable, I would imagine.
yeah,
So,
exactly. So that's just
yep.
an example of things that we've added, but we make it. I think the statutory form is probably about 3 pages, and ours is 7 at this point. So it's good to
So
customize.
I've got a fun question. We didn't talk about this one, but this comes up a lot.
All
And
right.
I always encourage my clients to go see an estate planning attorney that is licensed in the state they live in. And I still get the question of, well, isn't legal Zoom sufficient? Isn't these online options enough? Can you talk a little bit about what you know about LegalZoom or the online estate plans, if you will, and some problems you might run into?
Yeah. It depends a lot on what state you're in and what document you're trying to get from the internet.
Mhm.
I think for a power of attorney, I especially recommend not using one of these online situations because the language in those needs to be really specific depending on which powers you're trying to give to your agent.
Right.
I've seen, people come in with a power of attorney that they did from the internet and they're trying to assist whoever the principal of that document is, and the power of attorney is just not effective. Like there is just missing the specific enumerated powers that you would need to do that sort of work. So a lot of the internet ones that I've seen don't specifically say anything about
Right.
public benefits planning. So like for Medicaid, you may have to gift assets, you may have to change like liquidate retirement accounts if you're trying to qualify for Medicaid. And a lot of powers of attorney don't have that specific language that you would need to do that. And
Mm.
so at that point, you kind of have to go to the court, if the
Ends up being
principal,
legal fees, lots of
yeah,
legal fees.
exactly, legal fees.
Yep.
With a will, it depends on the statutes of the state, because some states do have kind of like catch-all statutes that say, hey, if they tried to make a will and these basic things are there, like we can figure out what they were intending to do. But again, that still is going to require more legal fees, and more
Mhm.
lawyer involvement at the end during probate. Um, don't try to do a trust online, just
Yeah.
period.
Yep.
Don't do it.
Agree. Agree.
It's just not,
I've
yeah,
had a few go very wrong just trying to abide by them when someone passes. And if even a clause is not right in the state you live in, they can get very picky.
yeah. And it might just not work for what you're trying to do. Like there's a
Mhm.
very high chance that if you try to put together a trust to do anything specific, there's just so many different considerations that go into all the different pieces. And these documents are really long and have a bunch of boilerplate language to address all the different situations that come up. So yes, the internet forms we are not super pleased with, but
Right.
like I said, the advanced directive is kind of an exception because it's literally written by the legislature. You can download it yourself, if that's something that you want to do. Get it from your
Yeah.
doctor's office. But we also, like I said, we revised it and made it a little bit better. So there's still benefits to seeing an actual estate planning attorney.
Right. Agree. Agree wholeheartedly. Well, thank you, Emma. I really appreciate you giving us some time to answer some of these common questions. We're going
Yeah.
to move into Q&A. So, for those of you that may have questions that you want to ask, and again, I ask that you keep them pretty broad, not your personal situation. Emma's going to put her information into the chat, and we'll also email it out later so you can connect with her if you want to talk about your personal situation. But we're going to open it up for some questions. Carrie, do we have any questions that we need to answer?
Rachel, there are some questions. Emma, I'll just read these and you can answer. And if anybody wants to type their questions in, I'm happy to ask them. Or Rachel, would you say that's okay for them to unmute
Yeah,
themselves?
it's
Okay.
fine if you want to unmute yourself to ask a question as well.
Okay, Emma, this question came through. My mom had a trust, but we still had to go through probate after she passed away. I thought that you said trusts avoid probate.
Good question. Yeah. So we kind of talked a little bit about this earlier, but the trust avoids probate if all of the assets are in the trust. If you forgot to put a bank account in the trust and there's no beneficiary on that bank account, you're going through probate because the owner of the bank account has died and there's no way to transfer it. With the trust is still around, still exists, and so if the bank account was in the trust, there's still an owner and we can just follow the instructions and transfer it that way. There may also, I obviously don't know the specifics there, but it could have been, oh, sorry, I'm getting distracted by the Q&A. If the trust maybe wasn't effective, if there was some reason that like there was a signature issue, then you would still have to go to probate and hope for the best there, depending on, yeah, I can't really answer more specifically than that because I'm not sure about the situation, but likely I would guess it was an asset that was not titled in the name of the trust.
Another question that came through, Emma, is all of my accounts are jointly owned or have beneficiaries on them. Do I still need to do estate planning?
That's also a really good question. We kind of have a third approach to estate planning. We call it piecemeal planning or patchwork planning. And that's a situation where, you know, all of your accounts have a beneficiary on them, your house is jointly owned with someone, or there's a transfer on death deed. So everything that you own, someone else is either a beneficiary or co-owns with you. In that situation, yeah, there's probably not going to be probate needed when you die. However, what if the co-owner passes away before you? What if the beneficiary passes away before you do? At that point, you're still going to need some sort of probate or estate planning document because uh, even if you have a beneficiary, if they no longer exist, then it's stuck. You need probate to unstick the asset.
And that's fun. I have a question that came through on my queue that I'm going to ask. Do you have any advice for special considerations for unmarried couples? So those who are not married.
Mhm. I think that it is more important almost for unmarried couples to do estate planning because, like I was talking about with the intestacy laws earlier, if you're not married, then your assets just by law go to your children if you have them, or to your surviving parents if you have them, and then it goes out from there. But if you don't make any sort of provisions for your partner, if you're unmarried, they're not getting any of your assets. So it's even more important at that point to do a will or a trust and power of attorney as well. Name each other so that you can transact on each other's behalf. Because while a power of attorney is necessary in most situations, you know, if a husband and wife go to the bank, you know, usually the bank will talk to the other spouse, but if you're unmarried, they definitely won't talk to the other person. So power of attorney is really important. Advanced directive, even bet more for unmarried couples because you may not be allowed into the hospital room if you're unmarried. You may not have any real authority to make those kind of decisions unless someone names you as a healthcare representative. So I think it's very important for unmarried couples.
Mm-hmm. I agree with that. Then you can decide.
Yeah.
Another question, and Carrie, if you have a few, let me know, but I've got, what is an islet and why would I need it? Familiar
Yes.
with islets?
Yeah, ILET's a life insurance trust. I personally don't do them, but I know that other people in my firm do. If you want to send me an email, actually, I can give you a little bit more information about that, whoever asked that question. I just, like I said, it's not part of my practice, so I don't know much beyond. It's a life insurance trust.
Mm-hmm. Okay. Another one that we had come into the queue. My fiance and I are planning to marry at the end of the year. We have made some provisions already about inheritances from IRAs. Should we do our estate planning now and update after marriage, or just wait and do it all after marriage?
Well, congratulations, number one. That's so exciting.
That was a mouthful. But I
I
get where
think
he's going with that. Should they do it now? Should they wait until after they're married? What do you think?
totally. I think there's a couple of things to consider there. The first thing that my brain went to is kind of just a logistics thing of, is anyone changing their name after they get married? And if so, probably you're going to want to wait until after, just because at that point you're going to have to
Redo
redo
everything.
all of your
Yeah,
documents. So
if there's gonna be a name change.
just with the name change alone, it's worth waiting.
Yep.
You know, if you have a honeymoon immediately after the wedding and you're going skydiving, it might be worth doing estate planning before that point, so that you have something in place. You know, that's kind of a little
Might
joke
be
we tell.
important at that point if you're
Yes,
gonna do something very risky.
exactly.
Oh, okay, I've got another question. To review the Oregon 1 million exemption with regard to the trust. Along with this question, I think part of it is, are accounts with beneficiaries? So if I have a bank account that has a beneficiary on it, is it included in that million exemption?
Yes, so the Oregon estate tax is calculated with both your probate assets and your non-probate assets. So that includes everything that you own, and life insurance too. So this, like you were saying earlier, Rachel, you know, you own a car, bank account, and a shack over in Southeast somewhere, that's $1 million. Like,
Mm-hmm.
so that's pretty
Mm-hmm.
easy to meet that exemption. So,
So regardless of if you have a beneficiary, it's still gonna get added into the estate.
exactly. Just for the estate tax purposes, you know, it's
Mhm.
not necessarily going through probate, but it is pulled in to calculate the estate tax. With regards to the trust,
I think just a review of how it worked was what
just a
that
review of how it
they were
worked. Yeah.
looking for. Yeah.
So really quick kind of example here with round numbers. If a married couple has $2 million when they're alive, spouse A dies. If there's no sort of planning, then the 2 million is owned by spouse B. And when spouse B dies, they only have 1 million of that exemption. So they're taxed on the second million.
Mhm.
If they do have some sort of planning in place, like we do with the trust, like I said, you can also put in a will. It is possible. I tend to put them in trusts. But if you have tax planning in place, then you have this 2 million, spouse A passes away, and in their will or trust, it says, take that $1 million and put it in a different vehicle. So credit shelter trust, a Q-tip, something like that. And then the surviving spouse can still benefit from that. They can still use it for their support if they need it for any reason. They still have access to it, but what it does is it kind of holds that in that first spouse's account for purposes of calculating that tax.
Protects it.
Yeah, so then when the second spouse dies, they also get to keep their 1 million exemption. So now you're saving $100,000 in taxes that you wouldn't have before. So now you get to have a $2 million exemption where you previously only had one.
If you have follow-up. Did that answer your question? You can unmute yourself.
Yes.
Okay, cool.
Great.
One more was the last time we did our will was 10 years ago and we need to update it. Have costs gone up extremely, or do you have a range on what it might cost to update a will or an estate plan?
That is a tough question.
Depends.
It depends. A joke with lawyers is the lawyer's favorite answer is it depends to any question. So
One of my favorite questions.
Right.
How much do I need to retire? It depends.
Depends. But 10 years ago, and if you are still located in the same, you know, city or area that you did it in, prices have gone up, but I'm not sure it would be extreme price hikes. I know that my firm can be a little bit on the pricier side, but I think that a lot of that is because, you know, we've been doing this for 40, 50 years at this point. And um, we do that post signing follow up that a lot of other firms don't do. So we really stay on you and make sure you actually funded the trust. You've gone to the bank, you've made the trust accounts that you need to do. And other firms sometimes don't do that. And so that's when you end up with a trust and still needing to go through probate. We try really hard to not have you go through probate if you can avoid it. If that's your goal, to avoid probate, we will make you avoid probate.
Mm-hmm.
But let's see,
So it
for
varies. Prices vary. Depends on
prices
what you
vary.
need.
Yeah, and it also like changes depending on what type of trust you're doing, if you're just doing a will or if you're doing a trust.
Yep.
Yeah, there's
You
so
can do a
much too much there.
complimentary consultation with her and she'll give you an estimate.